My name is Enrique. I'm a national organizer at Essential Workers for Democracy. I'm also a former member of UFCW Local 3000 here in Washington, where I was a shop steward at the North Bellingham Fred Meyer and a member of the local executive board. Thank you for joining us today on this national organizing training, Legal Rights of Union Stewards. Today's training is designed for shop stewards, but it's useful for all members. Even if you're not currently a steward, it's important to know, especially if you want to become a steward or holding current stewards accountable. Some folks may ask, why attend this training? And I'd say because our union contracts are only as strong as our ability to enforce them. And our union is only as strong as our organizing is on the shop floor. Remember, you are the union. So whether your union leadership is awesome or not so awesome, we're not organizing to enforce a contract. If we're not organizing to enforce a contract and our rights on the job, then the power of the union on the shop floor isn't very strong. By attending this training, where you're taking a step to member ownership over your union. We'll have a recording available of this training after the call. Think about sharing this recording with other stewards, members, coworkers, because together we can build a stronger and more active union. We're joined today by labor attorney Will Bloom in Chicago, Despres, Schwartz, and Geoghegan. He is also a board member of the Association for Union Democracy, a nonprofit legal aid resource for union members fighting for union democracy. At the end, we'll have time for Q&A, so please leave any questions you have in the Q&A function at the bottom of your screen. If you're not seeing it, press those three dots at the bottom. A couple options will pop up. We'll also hear from some current UFCW shop stewards about how they've organized in their workplaces. But first, please welcome Will.
Much, Enrique, and thanks to everybody for coming out this evening. I don't know if it's as sunny as it is here where you are, but I appreciate everybody being on a call on such a lovely evening. Yeah, like Enrique said, my name is Will. I am a labor attorney based in Chicago. I do a lot of things, but one of the things I do is trainings like this for rank and filers like yourselves. Yeah, I'm so excited to be with you tonight. Tonight's training is going to cover generally the legal rights of union stewards, but it's going to go beyond some of the legal rights of union stewards to what it means to be an effective steward. That includes not only a summary of the basic rights and responsibilities, but some somewhat deeper dives into a few important topics like the grievance process, information requests, your rights in meetings with management, and the duty of fair representation. And then, as Enrique said, we're going to hear from some non-lawyers who I think honestly have more to do with being a successful steward than what I can teach you at the end of the call. Um, as Enrique said, this is a call for all members. We're talking about what stewards can do, but even if you're not a steward, it's important for you to understand what makes for a good steward, what makes for an effective steward, not only so that you know what to expect from your stewards, but so that if you want to put your name forward for steward at some point, you know what you're getting yourself into. Um, Now, a note about grievances, this is a version of this training that is kind of across union training, and I'll give a shout out to Robert Schwartz, whose book it's blurring, whose book The Legal Rights of Union Stewards I think is an important, a fundamental text on this subject. Um, but yeah, this training has it's obviously been adapted and focused on the needs of UFCW members. But we talk about grievances a lot of the time in this kind of general sense, like there's one thing that a grievance is, and there's one way a grievance can work, no matter your union. But grievances generally are dependent on the specific language in your particular contract, on the past practice in your shop. They're dependent on the way your union does business. There's a lot of things that are context specific. I think what we've got in this training is pretty generalizable, but there will be differences shop to shop, contract to contract, local to local, and union to union. In the UFCW, generally speaking, stewards have a much smaller role to play in handling grievances. Staff usually have the power to file grievances, argue grievances, make the decisions about what grievances get filed. That said, most of the steps in a grievance are important to the job of being a steward, whether or not the steward ultimately has a say in how that whether or not that grievance gets filed, how it gets filed, arguing that grievance. So we're still going to talk about a lot of those key steps, which I think that stewards should be engaged in, whether or not they're formally given that role in the process. Um, so yeah, what is a steward? What does a steward do? A steward has many roles, and I think a lot of them kind of fall under this first one, which is leader in the workplace. You are the person who's been chosen to be, the kind of representative, the connective tissue between individual members in your shop, and the larger union. When people have questions, when people have concerns, you are in a functioning union in a functioning shop. They're probably one of their first stops. And it's important to both be able to help them and also to just set a good example of what it means to be a good trade unionist in your shop. Part of what that means is you're an agent for the union in kind of a legal sense. You represent the union on your shift, on your unit, depending on how your steward situation is organized in your shop. Um, you're a communicator. That doesn't just mean, hearing something from a fellow member and communicating it up the chain of command. It means communicating within the unit. If you hear from somebody, I've had this concern with this manager, I'm having this issue with my schedule. Part of your job is to talk to all the other members around you and say, are you hearing about this problem too? Are you experiencing this as well? And figure out if there's something broader. That communication is absolutely fundamental to being an effective steward. This relates to being the eyes and ears of the union in the shop. You got to be keeping an eye out for problems that might be emerging. There are problems that an individual member might not notice on their own, and part of your job is to collect all that information and understand what's going on. You are a representative of not only the union, but of members in particular contexts. We're going to talk about disciplinary meetings tonight. And in those disciplinary meetings, you as a steward have a very important role to play in representing the interests of your member in that context where they might be facing, discipline, suspension, termination. You've got a very important role to play there. Stewards are also, and this is, I don't think going to be a surprise to anyone here. Stewards are organizers. Stewards have a responsibility to help build power, build cohesion, build trade union consciousness among their coworkers, so that they understand that they've got the power, that we've all got the power together. That role as an organizer is, I would say, one of the most important roles that a steward can play in their shop. Stewards are negotiators. There are formal processes for resolving disputes, but more often than not, a steward interacting with a frontline manager is and reaching some kind of agreement, some kind of deal is what's going to resolve a lot of disputes that arise in a shop. So being able to engage in that kind of negotiation, to have that kind of back and forth with the manager and figure something out, is really crucial. You're an educator. I mean, we're going to talk later about what you need to know as a steward. That includes knowing your legal rights, knowing your contract, and part of you knowing that is making sure everybody else knows that, making sure your coworkers understand what their contract is, what they're entitled to, what rules they have to follow, is a fundamental part of being a steward. A steward is a political activist. I think as you discover issues and as you organize around them, you also have, part of your role is to connect those particular issues to broader political fights around, like, well, what is the relationship between your union and the boss in a broader sense than just like your particular shop? What are the broader, politics means power. What are the broader power, what is the balance of power between you, the workers, and your boss? And doing that kind of organizing around those bigger political questions is going to build the power of the union. And finally, you're a problem solver. This kind of encompasses everything else, but you've got an obligation to to figure out when there's a problem and see if you can solve it, and if you can't solve it by yourself, figure out how the group can collectively solve that problem. So that's what a steward does. But what are the rights and responsibilities of a steward? And again, I think some of the basic responsibilities of a steward on a really fundamental level are to know your rights under the National Labor Relations Act, under any state laws when it comes to minimum wage, maximum hours, sick leave, paid leave, any number of things like that. your rights under the contract. Um, and that gets into the second thing you need to know, which is your contract. Your collective bargaining agreement it's probably quite long, but it contains most of the information about what you need to know. Since such an important part of being a steward is enforcing the contract on the shop floor, knowing what you're enforcing is absolutely fundamental. If you don't have a, you know, if you, I know we live in a digital age, but having a paper copy of your contract is, I think, necessary. Um, Not only reading it, but annotating it, taking notes in it, knowing how, the seniority provision and the leave provisions interact with each other or with the scheduling provision, having a sense of that, you can't just look something up necessarily. You should always look something up if you don't know something, but you can't just always look something up when an issue arises. You kind of have to have a feel and a knowledge of that contract in order to issue spot, in order to see something and realize that's a problem in the first place. And the third thing is you got to stay connected to the issues of your union. Your members are going to have problems, they're going to have concerns, and part of your responsibility is to know them, is to talk to everybody and figure out what's going on in your shop. So those are some of the kind of basic responsibilities, but it's not just about responsibilities; it's also about what rights you have. So your basic rights as a steward are to represent and lead your members. You are, you're the leader in the shop. You've been chosen to lead that shop, and you have a right to represent those members. We'll talk about, participating in investigatory interviews. You have a right and really a responsibility as well to defend your member if they are facing discipline. You have a right to information. We're going to talk a good amount about information requests. But in order to do your job as a steward, you probably don't know everything you need to know, and you have a right to request information from the employer in order to get the information you need to pursue a grievance, engage in bargaining, just to understand what's going on. We'll talk about that as well. You have a right as a steward to be free from retaliation. Um, the whole system of collective bargaining in this country and in most countries is a departure from half a millennium of legal understandings of the relationship between a boss and an employee, between a boss and a worker. For 500 years before the National Labor Relations Act, the law understood workers to simply be an extension of the boss who have to do whatever the boss tells them, and if they don't, the boss can fire them. But that kind of superiority of the boss is challenged by the labor relations regulations that we have in this country. Because when the union and management engage with each other on those terms, they are supposed to legally engage on equal footing. The union and the boss are supposed to engage with each other as equals. Now, we know, as a matter of reality, that there is a power imbalance there in terms of the power of capital. We, as unionists, we, as workers, are organizing to address that power imbalance, to build worker power so that we can actually be on an equal footing. But legally speaking, you're entitled to be on an equal footing when you are representing the union as a steward, when you're representing your members as a steward. That means that the boss can't retaliate against you for things you do as a steward. Even when, we'll talk about this later, things might get a little heated, things might get combative, confrontational. The point of labor management relations is that it's supposed to be a little confrontational, that the interests of management, the interests of the union are opposed in many situations. They are certainly in every situation distinct. And that means that you have a right to be treated as an equal when acting as a steward and a right to be free from retaliation when you're acting as a steward. Um, so those are kind of your basic your broad rights, but you also have specific rights when you are representing a member in a particular situation. When a member is facing discipline, they have a right to request that you be present in any investigatory meeting or disciplinary meeting. We're going to talk about Weingarten in just a second, your Weingarten rights. You also have a right in those meetings to know the specific charges being investigated. They can't just go on a fishing expedition. They actually have to tell you, this is what we think happened. This is what we're looking into. And you have a right to caucus with your member during any meeting like that. You can say, all right, we've talked for a bit. I need to take some time to talk with my member and figure out what's going on here. Um, Now, under Weingarten, this is, for those that are familiar with the labor movement, this is not a reference to Randy Weingarten, who's president of AFT. Weingarten was a department store in, I think, New York in the 60s. There's a case called NLRB v. Weingarten, in which the Supreme Court said that members of, recognized bargaining units have a right to have a representative of the union with them in any disciplinary meeting. Now they have to actually invoke that right. The boss is not going to tell them you have a right to this. They don't automatically get to have someone in there unless the contract provides otherwise. The member needs to know they have their Weingarten rights, and they have to actually say, "I'm invoking my right to have a representative of the union with me in this meeting." Otherwise, they can just blow forward and have this disciplinary or investigatory meeting without the union rep present. So again, this goes back to your role as a steward, as an educator of your coworkers, to make sure that they understand that they have to invoke their Weingarten rights if they want to enjoy them. Um, Now, you can't just have a Weingarten rep in any meeting with management. You are entitled to having your representative with you if the boss is asking you questions, and the worker has a reasonable fear of discipline arising from that meeting. If the boss is just saying, "How's it going?" You can't say, "I want my union rep." But if the boss says, there are some boxes missing from the storeroom. Where were you at 3 p.m.? That's a time to invoke your Weingarten rights. Now, in that meeting, the steward has a number of rights. They're not unlimited, but the steward can give advice to the member on how to answer a question. Obviously, don't advise them to lie, but you can, help them through that process. You can tell a worker when not to say something, when saying something might be a boneheaded move. I I just last week I was talking to a friend of mine who's a steward at not in the UFCW but at UPS, who was in a Weingarten meeting after a coworker had been disciplined for saying some, let's say, rude things to a manager. The member was maybe justifiably angry, but maybe unjustifiably expressive in that anger. And the steward had managed to, talk it through with the supervisor and got them to agree not to pursue discipline. And the member started to say, "Well, but I still think I was right." My friend basically elbowed them to get them to shut up. And we'll part of a steward's job sometimes is telling a worker when to stop talking. That's an important thing to keep in mind. Um, but a steward also has a right in those meetings to object to intimidating questions. The boss is allowed to ask questions that are directed at, surfacing relevant information. But badgering somebody, abusing someone, harassing them, intimidating them, that is not acceptable behavior. And the steward is entitled to say that's not acceptable behavior. Um, the steward can also give mitigating or extenuating circumstances. They can make an argument on behalf of the member if they're facing discipline and try and save their hide, give reasons why discipline should be lessened or why the ostensible alleged violation isn't actually a violation. Um, and they can give their own witness. Depending on the shop, a steward can say, "Well, I was actually there and that didn't happen this way. Here's what I saw." Um, an important thing to keep in mind in these meetings, be zealous in your representation, but be respectful. You should firmly and clearly represent the member's interest. The equality principle gives you protection, but it can't, the steward can't overstep into egregious behavior. We'll talk a little bit about that later, about what that line looks like. And part of zealous representation is in caucus, not in front of management, being honest with your coworker. I know of so many examples of a member facing discipline, and the steward goes into the Weingarten meeting, goes into the disciplinary meeting, and fights hard and stops a serious discipline from happening, and then gets in caucus with the member and tells them, "You really messed up, and you can't do that again. It's bad for you, and it's bad for the union." And being honest with members about that, not in a way that prejudices them or their disciplinary case or otherwise harms them, but in private, telling them when they've got to shape up is actually a pretty important thing, not just for your representation of that particular member, but for your representation of all your coworkers. So I think that's an important piece of being a good steward to keep in mind, is that you represent everybody and you also represent each individual person. And there's a tension there. And we'll talk about the duty of fair representation later, but it's a tension that I think is productive and that a good steward can handle. Um, okay, we're gonna have a few polls throughout the evening. Here is our first one, and I think Enrique and Caitlin are gonna get this poll going. Um, but our first question is, do members have to invoke their Weingarten rights in order to receive representation during a disciplinary meeting? I do not have the Jeopardy music queued up, otherwise I would play it for us as everybody gets their votes in. I will not be singing it for people because I want to spare everybody that. All right, we'll give it 5 more seconds. I think most people have voted at this point. 4, 3, 2, 1. All right. I think most of you hit the nail on the head on this one. Yes, unless your contract says otherwise, a member has to invoke their Weingarten rights in order to receive representation during a disciplinary meeting. Um, yeah, as I said earlier, that's a really important aspect of educating your coworkers. A lot of unions will have little cards with Weingarten rights on them. If you've got those, you can hand them out. If you don't have those, you should really talk to your union about printing them. Pretty cheap way to do some political education in your union. Um, all right. So just a few more notes on rights and responsibilities. You are an agent of the union in the workplace. You have certain rights, but those come with responsibilities. And the main one is the duty of fair representation. We are going to be talking about this later in the training, but stewards and the union as a whole owes a duty of fair representation to everybody in a workplace you represent. And an important thing that does not that duty of fair representation is not limited to members of the union. That includes anybody who works under the contract, who works in a shop that has the union as their exclusive bargaining representative, whether or not they want to pay their union dues, whether or not they want to be a member of a union. If you're in a right to work state, a non-fair share state, a free rider state, as we like to call it, this is a really important thing to keep in mind. When it comes to your duty of fair representation, you cannot treat the most anti-union, annoying scab in your shop any different than, your most committed union activists when it comes to enforcing the contract. That is what the duty of fair representation requires. We'll talk more about what that means later, but the basic principles are you can't treat unit members in an arbitrary, capricious, or discriminatory manner. You have to treat similar cases equally, and you have to investigate and have reasons for the decisions that you make. And again, we put it in here again because it's really important. Enforcing the agreement requires knowing the agreement. Contracts can be complicated. You can always ask for help. You can always do research, but knowing is half the battle. Next, we're going to talk about grievances and generally what they are and how to approach them. And again, I understand that this is UFCW is structured a little differently than other unions in this respect, but I still think stewards, whether or not they get to file and argue grievances themselves, have a really important role to play in preparing grievances. And I think I suspect most stewards are much better suited to actually investigating and preparing grievances than most staff organizers or business reps are. So, what is a grievance? A grievance can be over a number of things. It can be over an explicit violation of the contract as written. Contract says, Jane gets paid $17 an hour. Her paycheck says she's getting paid $16 an hour. That's a grievance. It can be a violation of the company's own policies and procedures, because that basically, as we'll talk about, kind of establishes a past practice. Since forever, people have been allowed to punch in up to 5 minutes late without getting dinged. They've suddenly stopped doing that. Grievance. It can be unfair treatment to an individual or a group. It doesn't just have to be, person A was harmed by this grievance, and so there finally it can be something that affects everybody in a certain job classification or on a shift or everybody in the entire shop. That can still be a grievance. A violation of past practice, I already went over, and then a violation of law. Most contracts have provisions requiring the parties will follow the law. Um, and so if the boss is, violating discrimination law or violating other laws that exist, that can be the subject of a legitimate grievance. Um, so yeah, don't tell me, I guess. But arbitrations are not won by lawyers in most situations. Arbitrations are won by the steward or the committee person who crafted the grievance. Even if you're not the staffer who gets to file it and argue it, the crafting of the grievance, the investigation, and the preparation that go into a grievance are what make the difference 9 times out of 10. That means doing a good job actually writing the grievance. In order to do that, in order to do that, you need to do a good job investigating the grievance, and we'll talk about grievance investigation in a second. And that really requires amassing relevant evidence. Relevant evidence can include both written documents or other kinds of video, but material evidence, and then witness statements, talking to everybody involved and figure out what happened in a particular instance. So yeah, grievance investigation is really one of the most important parts of handling a grievance. And again, even if you're in a shop where staff is going to be handling the formal aspects of a grievance, you are uniquely suited in most situations to handle the grievance investigation. Your first step in a grievance investigation is talking to the person who's been harmed, talking to the member who's brought this issue to your attention. The important questions you want to ask, and obviously be many follow-up questions to this, but these are the things you want to make sure you've answered by the end of that initial interview. The who, what, where, when, why, and then what the remedy, what's going to fix the problem. These are basic journalist questions, but also you need to know what's actually going to address this. They're sometimes it's a lot easier to identify the problem than to figure out how to fix it, even if you had all the power in the world. And so crafting that remedy that you're going to request in that grievance can be a very important and difficult part of the process. But it's important to go into that investigatory interview knowing that you want to be able to figure out what's going to make the member who's been harmed feel whole. So important information to request from the aggrieved party. What is their work record and history? How long have they been working there? What's their job been like? Have they had any previous issues? Their seniority date can be very important, especially when it comes to a seniority or pay or scheduling grievance. Their disciplinary record, especially if it's a grievance over a discipline. Is this someone with a spotless record or someone who's been through the process a few times? That's going to be very important to making your case. And it's always important, I think. I do this as a lawyer in basically any conversation I have with a client or with someone I'm trying to learn something from. Ask them, is there anything else you need to know? You may have a sense of what you need to know, but generally speaking, the person who actually experienced the issue is going to have a much deeper understanding of what happened than you are, and that includes knowing what you don't know better than you do. At the end of that initial conversation, I think it's really useful first to recap what you've learned, what you've talked about, make sure, just repeating back what they've told you. Sometimes you'll discover you misunderstood something they said or you wrote it down wrong, or it will lead to a new line of questioning. So just recapping what you've learned to make sure you're on the same page about the facts. Um, Kind of give your initial impression of applying the contract to the facts, why you think it might be a grievance, what you think the relevant contract language was, what just cause principles you think might have been violated. You don't want to wedge yourself to that, but giving kind of an initial impression, I think, can be very useful to people. Explaining the next steps in the grievance process so they don't get left hanging, but understand, so now this has happened, now this is going to happen, and this is going to happen, and so on. And a really important thing, even if it seems like the most cut and dried case in the world, never promise victory. I can tell you as a lawyer, there are so many ways any legal process can go wrong. So making sure that you are not promising something that you cannot promise is just so important. Don't do it. Um, so once and we'll talk about information requests, but you'll do that initial investigatory interview. You'll talk to other people who might be involved. You'll request documents. The next step after that is to write the grievance. And again, this might vary shop to shop, but even if your steward is the kind of bottom liner, you'll want to try and play a role in crafting the grievance, especially if you did the investigation. It's really important to understand timelines, especially to the duty of fair representation. Make sure you do not blow a deadline. Know when you have to get the grievance in so you don't miss that deadline. Um, it's important to use brief and accurate information, and to stay away from inflammatory language. The kind of key thing here is you are laying out the facts, and then you are laying out the contract language or the past practice or the law that is at issue, and then you are applying that contract language or law to the facts. You want to stay away from subjective statements. Focus on what you objectively know to be true and the facts you've discovered through your investigation, and avoid, it's not going to be helpful. Understand your audience. Your first audience is going to be management, and eventually your audience may be an arbitrator. And neither management nor an arbitrator cares if you think this is egregious, or that this manager was an asshole or whatever. Like, that's not going to help your case. It's important to stay focused on the facts that are relevant to the violation you are alleging. Um, and it's fine to ask for help. You can always say to, your staffer or to your fellow stewards, how would you approach this question? How would you write this? Help is good. We're a union. We're many coming together to fight as one, and so don't be afraid to lean on the many. The three steps to agreements, the three parts that an agreement is to have are the facts, the violation, and the remedy stop. This is kind of what I was getting at. You want to lay out the facts, lay out what contract language or law or past practice has been violated, and then lay out how it's going to get fixed. What you are asking management to do to address the problem. All right, it is time again for a poll. Soliciting grievances, true or false? Shop stewards are not allowed to solicit grievances. If we can, yes. All right. All right, we'll give it like 5 more seconds. Okay. Again, I think most of you nailed this one. Yes, shop stewards are absolutely allowed to solicit grievances, unless I don't know of any contract that limits that, but unless your contract limits that, you have a right to go around and say, hey, I, heard this might be an issue. Is this an issue? You should really file a grievance. Let's put it together. That is part of your job as contract enforcement, is making sure people know when they actually have a grievance. Not everybody's going to know that this bad thing that happened to them is actually a violation of the contract. So that's a really important role for you to play. All right. Next up, we're going to talk about information requests. And we're going to jump right into another poll. True or false, management has to turn over information to the union. Votes are rolling in. If you're in line to vote, stay in line. We'll give it 5 more seconds here. All right. Again, you guys are experts. True, yes. Management, within some limits we'll talk about, has to turn over information to the union when it is requested. The National Labor Relations Act, which is the federal law that, you know, regulates everything we're doing here, that regulates private sector unions, requires an employer to bargain with the union, and the law understands that in order to bargain, we need to be able to know things. We need to be able to request information relevant to bargaining. And bargaining includes contract enforcement. Um, Further, Section 885 of the NLRA makes it illegal to refuse to bargain, and that includes making it illegal to refuse to provide relevant information in a reasonable period of time. Those are both two real fuzzy words as courts understand them, but generally speaking, relevant information is pretty broadly defined. It's anything that pertains to the terms and conditions of employment or is necessary to enforce the CBA. Typically, that relevant information standard goes back 2 years. That's kind of the rule of thumb that the board has created over the years. Obviously, there may be situations where you need to go further back, but a longer timeline than 2 years will need to be justified. It can't just be assumed in the way that kind of 2 year thing is kind of the baseline. Um, so what information can be requested? Almost anything. Or I guess sorry, I jumped a slide. What should information requests include is first, the first thing you should do is a statement that the following information is requested pursuant to the union's right to request information under the NLRA, just some nice legalese to make sure they understand that you know your rights. A description of the information sought that is, sufficiently specific for them to gather the information, giving them a deadline to provide that information. It's got to be a reasonable deadline, as the language on the last slide showed. 3 days is too short, so it can't be shorter than 3 days. And if the company doesn't respond by that deadline, you should re-request that information and point back to the original request. Make sure it's clear in that request, in the new request, that you already requested this. Give a new deadline, and if they don't make that deadline, then you are safely able to file an unfair labor practice with the NLRA or with the NLRB over that violation of the statute. Um, so now, what information can a steward request? Many, many things. Documents, which is a broadly defined term in this context that can include accident reports, attendance reports, contracts, not only your own contracts or side letters or memoranda, but contracts of other units and facilities. If you are bargaining, with grocery stores, if you're bargaining a contract for a grocery store in Connecticut, you might want to know what the company is agreeing to at their grocery stores in Rhode Island. That's going to be pretty relevant, so you're entitled to request that. Bargaining notes of management, especially if it becomes if there's a question of what does a contract term mean, there's some dispute over what the parties meant when they agreed to a particular contract term, you have a right to request management's notes from bargaining to see, well, they're saying they understood it to mean this. Is that what they understood when they were actually bargaining it? Let's take a look at those notes. You can request customer lists, disciplinary records, employer manuals, interview notes, investigative reports. Those are going to be especially important when it comes to disciplinary cases. Um, Job descriptions and schedules, time cards, videotapes count as a document for these purposes, wages, salaries, all of this is fair game as long as it's relevant to a particular issue at hand. And I should note when it comes to wages and terms and conditions of employment, um, those kind of basic things, you don't have to give a reason. If it gets a little far afield of that, you have to say why you're requesting it. But for those basic things, it's assumed that it's relevant, and you don't have to defend its relevance in an initial request. But in addition to documents, you can also request facts. What in courts and litigation we would call interrogatories. In a misconduct case, you don't just have to request documents. You can say, "Well, give me a list of the names and addresses of all the witnesses, and what testimony they've given the employer." For an arbitration hearing, you can ask for the names of the person they intend to call to the stand. Um, you can also request data. If there's a dispute over overtime assignments, you can request data on all prior overtime assignments. Make them give you their spreadsheets. In disciplinary grievances, you request a copy of the grievance personnel file. For contract interpretation grievances, you can ask for those bargaining notes. You can ask for the dates and contents of any union statements upon which the employer intends to rely. You can really get into it, and you can ask what might seem like some invasive questions, but that's necessary to fair bargaining. So now we're going to have a number of really fun polls. We're going to get back into quiz time. So this poll, two workers are involved in a fist fight in the plant. Only one of the workers is disciplined. The union requests the personnel file of both workers. The company refuses to provide the file of the worker who is not disciplined. Is the union entitled to this information? We'll give it 5 more seconds. 3, 2, 1. All right. Yes. Great. Oh, did everybody see that poll? Yeah, so yes, the answer is yes. The union is entitled to that information. Um, whether or not whether or not the person who wasn't disciplined is party to the grievance, not only does the union still represent that guy, but knowing why, if there's any basis for the disparity in discipline, is absolutely relevant to the grievance before them. All right, our next poll. A worker was discharged for leaving early and not punching out. The union believes that other workers guilty of this offense in the past received lesser penalties. The union requests the disciplinary records of the other employees. The company responds that the disciplinary records of those other employees are not relevant. The company representative says that if the union gets permission in writing from all the other employees to review the records, the company will consider the request. Does the union need written permission? We'll give it 5, 4, 3, 2, 1. No, the union does not need written permission. This is clearly relevant information, and the union is entitled to know it. All right. And then one last request for information quiz question. The union suspects that the company has been in violation of the equalization of overtime language in the contract. It requests records of all overtime worked in the last 12 months. The company informed the union that it is not required uh, to supply that information because there is no active grievance filed over the overtime issue. Is the union entitled to this information? And answer the first question here. We'll talk about the second question in a second. But is the union entitled to this information? 3, 2, 1. Yes, the union is absolutely entitled to this information. You don't need to have an active grievance on file in order to request information. Investigation into a grievance is absolutely just as good and important and allowed a role for RFIs as investigating a grievance that's already been filed. Now, can we get the information for 5 years? Probably not. As we noted earlier, the kind of standard is 2 years. Unless there's a good reason to ask for all 5 years, you're probably not going to be able to get that. All right, next up, rights in meetings with management. This is my favorite quiz in the whole presentation. Can a steward swear at a manager during a grievance hearing? Give it 5 more seconds. 4, 3, 2, 1. A split decision among the group. The answer here is within reason, yes, a steward can swear at a manager during a grievance hearing. This is connected to the equality principle that we talked about earlier. Management and the union are on equal footing. And in addition, the law understands that sometimes these things can get heated, that it is an inherently confrontational and adversarial relationship between management and the union, and they understand that in the heat of the moment, some things get said. Now, there are limits on that. You can't make that, obviously, you can't make any threats of violence. You can't say particularly egregious things, slurs, that kind of thing, obviously, is unacceptable. Um, but calling your manager an asshole is generally going to be okay. I did a version of this training a few years ago with a longtime steward in an auto shop in an auto plant. And the way he put it is give as good as you take. If the manager on the other side is, a church deacon who thinks darn is a swear word, calling him an asshole might be seen by an arbitrator as a little more unjustified than if, the guy you're on the other side of the table from is also a guy that you are, drinking with every night. Like the nature of the relationship can really get at it. But generally speaking, yes, you have a right to engage in behavior that would not otherwise be acceptable in the workplace within limits. Um, we could talk a long time, I think, about these factors. And just to give you an example of the kind of fluid legal situation around some of these issues. What I've described as the policy was the policy for a very long time. And then in 2020, in a case called General Motors, the NLRB changed that policy. That this is a particularly wild case where a white manager and a black steward were going at it. The white manager was being quite disrespectful to the black steward. The black steward started basically making jokes about that fact and drawing attention to the way in which he was being treated. Used some fiery language. And under the existing, what the standard was at that time, existing standard, what he was doing was totally within bounds. But the Trump board at that point said that the behavior went beyond what was appropriate. The chairman said this is a long overdue change to the NLRB's approach to profanity-laden tirades and other abusive conduct in the workplace, made it easier for employers to discipline stewards for engaging in protected activity. And then last year, that decision was overruled in a case called Elastomers, when the Biden appointed board went back to the original standard and said this was the standard for many decades, made a lot of sense. I don't know why we reversed it. We know why we reversed it. It should be noted, of course, that the current board doesn't have a quorum, but our current president, President Trump, has made nominations to fill that board, and it's entirely possible that within the next few years, the board flips back again to the old standard. So this is a really important part of the educational aspect of being a steward. You need to make sure you are staying up on the relevant law, especially when these laws can change with the administration. Um, but this is a good example of that requirement. All right, next up we have the duty of fair representation. This is really important because this kind of gets into not only your responsibilities, but the potential liability for you and the union of not following your duty of fair representation. So, the duty of fair representation is basically the obligation that you owe to your members to represent them fairly. Um, in a lot of cases in unions, we talk about DFR, the duty of fair representation, DFR cases. In many cases, they are being brought by people who are anti-union, and that's not great. But it's important to keep in mind that the origin of the duty of fair representation actually stems from a place that I think we would all agree is very good, which is Southern unions in the 40s not providing fair representation to non-white workers in the shops that they purported to represent. The court said you can't racially discriminate among the people in your shop. You have to represent black workers just as well as you represent white workers. It's an important principle. As it applies to you, the kind of core tension, but which I think is a good and productive tension, is juggling the rights of an individual member against the rights of the whole of the shop. That can't be easy it's not always easy, but I think it can be done. And I think the starting question for that is anytime you have to make a decision or take an action as a steward is this fair? Stewards even have to provide representation to guilty parties. Everybody's entitled to due process. You don't have to, you're allowed to exercise your judgment in terms of what grievances you pursue, but you have to act with reason. So the key things to remember, don't forget to process grievances in a timely manner. Calendaring is so important. Make sure 10 days, 15 days, how long you have to file a grievance and making sure you do not blow that deadline. Don't forget to communicate with your members about that grievance. Do not leave a member in the dark about what's going on, because that is where frustration can fester, can grow, and that can lead to a very angry member who might believe that their duty of fair representation has been violated. And relatedly, make sure that you are providing members with the information and documents related to their grievance. Make them feel a sense of ownership over their grievance. That's not just for the reason of avoiding a DFR, but as we're going to talk about in the last section, what you're doing through the formal grievance process is, maybe even less important than the organizing work that can be done around that grievance. And in order to organize around that grievance, the member needs to understand what's going on. So be sure to share that information. Um, the bottom line, the union is required to provide due process, and whatever it does, it needs to be consistent and fair. Um, like I said, an employee does not have an absolute right to have every grievance arbitrated. The union is not only entitled but obligated to make good faith, merit-based assessment of each grievance and decide whether it is worth pursuing or not. But an explanation and a good investigation is essential. You have to be able to act with reason, and in order to act with reason, you need to know the information that's relevant. Always notify the grievance in writing at the time and place of any grievance meetings, hearings, arbitrations, and invite them to attend even if they're not permitted to participate. An informed member is more likely to be okay with the result than one who's been kept in the dark. If the union decides not to arbitrate a case, notify the employee in writing of the decision and the reason for making that decision. If you have an internal appeal process for deciding not to pursue agreements, make sure the member knows that as well. At every step, this goes back to, is there anything else I should know? Ask the grievance if they have anything to add. Make sure that make sure that grievance feels like they're part of the process. Anytime there is such a meeting or an event, something that happens, make sure the grievant knows what the results are. Again, don't leave them in the dark. Make sure they know stuff. Document your efforts. Every interview you have, every call you have, every step you're taking in that process, make a note, keep track, have a log. Because if, God forbid, it becomes an issue where you're having to defend yourself in court, being able to document that you did your job, as a steward is going to be very important. And again, this is in this presentation many times because it's really important. Don't miss deadlines. Have a reliable calendaring method, whether that, whether it's Google Calendar or written calendar, something. Make sure you're not blowing those deadlines. Um, so yeah, that's the basics of the duty of fair representation. Our final section is strength in numbers because as much as we've been talking about the law, it's not really about the law. Your power as workers, our power as workers, is so much greater than anything that can be committed to a contract book. Our power as workers is what won us our contracts in the first place. While you should obviously pursue the kind of formal grievance process, it's important to organize around grievances as well. Get the grievant involved. Don't be the only person in your shop who knows the contract. Train your coworkers to be able to read the contract as well. Develop people who can help you with investigations. Because it's important for a lot of reasons. One of them is you need to know the contract, you know what to look out for. Um, the union will be stronger if everyone knows what's in the contract and knows what to keep an eye out for, and your job becomes enormously easier. Second thing is you can make it a group grievance. If there are, if one person comes to you and says, I'm having this problem, do your investigation. If it turns out everybody's got this problem, then have everybody sign on to that grievance. That can make it a lot more powerful. And in addition, there's a lot of things you can do to address an issue besides filing a grievance. You can collect signatures on a petition and organize people to present that petition to the boss en masse. You can have a t-shirt campaign or a button campaign. You can do a march on the boss. You can do an informational picket. You can work to rule. And if your contract allows it, you can go on strike. And to talk about some of what that looks like, I'm going to throw to Enrique to bring up two phenomenal UFCW comrades who've been doing some really fantastic work.
Ooh, thank you so much, Will. Really appreciate that. Now yeah, like Will said, we're going to hear some examples from UFCW stewards. Stewards have organized around problems at work. So first, we're going to hear from Dylan, the shop steward from Albertsons in Southern California in 324. Dylan, can you tell us a little bit about what the problem was and what steps you took to fix it?
Yeah, thanks, Will. Thanks, Enrique. So first of all, hey everyone, my name's Dylan. I'm a shop steward at Albertsons in Westminster, California, which is the store I've worked at for almost 7 years now. So our store, we had an issue where the fryer vent in the deli department, which hadn't been working for years, which, particularly on days when the fryers were being used extensively, it led to clouds of smoke and this horrible burning smell which circulated throughout the store. And so my primary steward, who's on the safety committee, which is something that we're able to get in our last contract, he made management put in a work order, but nobody ever came out to repair. So either they put the work order in at low priority because it's cheaper, or they just lied about putting it in altogether. So that's when we decided to push the issue. So what we did is we went and talked to my coworkers in bakery and deli and asked them if they would be willing to make a statement which emphasizes how their health and their safety are being affected. And I think naturally it can be hard for people to speak out because they fear being retaliated against. But with just a little bit of encouragement and just emphasizing that we're all in this together and that we're doing this for each other, we were able to get a good amount of statements from both departments. And so, I sent these statements to my rep, and my rep sent them to corporate. And the very next morning, our manager came in huffing and puffing because she had to put in an urgent priority work order to get it repaired. And literally the very next day, it was fixed. So all it took was just a little bit of collective action, and that's ultimately what got the job done.
Awesome, Dylan. And how did it feel for you and your coworkers after that win? Get it like immediately.
It felt good. I mean, because this is something that's been going on for years, and it just felt like this whole bureaucratic process. But yeah, I mean, I think it was really empowering. That's all it took was just for us to speak out in unison, and that's what really pushed it.
Awesome, Dylan. Thank you so much. Really appreciate that. Thanks for sharing your story. Next, we're going to hear from Amy in Indianapolis Local 700 about organizing Solidarity Shirt Days during their contract campaign. Amy is not currently a steward, although she has served as a steward for many years. She organized with her two current store stewards, Saeem and Janice, to organize their store's first ever Solidarity Shirt Days after Kroger workers in Indiana voted to reject their contract twice. They're still fighting for a fair contract now. Amy, can you tell us a little bit about how you, Janice, Saeem got started organizing Solidarity Shirt Days?
Yeah, and actually Saeem's not a steward, but he should be. He's the one that really he took the helm on that, and he said we're all wear the same color shirts on the same day to show some solidarity. And he told Janice and I that, and Janice and I talked, and then we were talking to some other people about coming up with a color to wear that stood out. And we decided on yellow. And yellow is one of the UFCW colors, and we have blue aprons, and that's another color of the UFCW. And so we decided to wear yellow because it stood out. And then I also I knew that a yellow union is a company dominated union, and so I wanted to sort of send a bigger message there. And so we all wore yellow, and management took notice, and it has kind of spread. And I know out in local 8, Golden State, Eric Marquez out there, he went and got yellow tape, mass duct tape, and they taped it on their arms after they saw the pictures of us all wearing yellow. So it's just we're organizing to do it again. Hopefully next week or the following week. I'm not sure what uh what what day we'll do it. I know Saeem's on vacation next week, but that's what we're working on, and I know other stores are working on doing the same here in local 700.
Yeah, and how were those conversations talking to people about Solidarity Shirt Days? Can you walk us a little bit about how your conversations went with coworkers?
Like what we say.
Yeah, like I'm sure people had questions, maybe even a little hesitant or some fear. How were you able to kind of overcome anything like that?
I don't know as though anybody really had any fear at my store about doing it. They just said, why yellow? And we explained to them why yellow, that it was really going to stand out. And that it was important to send a message that we're all standing together on these things. And everybody seemed to be pretty down with it. And as many people as we could get to wore yellow.
Yeah, I see the picture up there. that we're sharing on the screen here, everybody looks
Mhm.
really happy. It really feels like a moment was made there. So after
Mhm.
taking these pictures, did you have conversations about maybe doing it again? How did your coworkers feel? What was the energy like?
We've talked about doing it again, and we've talked about maybe changing it up a little bit and doing either tape or there people had talked about doing yellow clothespins. Was another one, like just pinning a clothespin. They have yellow clothespins, pinning them on your shirt or your apron, and just doing some things that stand out. Because not everybody has a yellow shirt, or not everybody wants to go buy one. So maybe going a little bit cheaper route with tape or a clothespin. And plus those things stand out too, so it's noticeable.
Yeah, yeah, absolutely. Absolutely. I think like you're getting at, right? Once people see it's very visually apparent. So once coworkers start seeing it, they start wondering, right? They're like, how
Yeah.
come you know this?
Yeah, and people ask questions, customers ask questions, and management definitely notice, and we don't have problems with our management like that either, though. So I mean, they didn't, they noticed, but they weren't hostile or anything. In fact, they were the opposite, complete opposite of hostile. So they understand what we're doing and why we're doing it.
Yeah, and I bet it's a little hard to confront that when it's a majority of the store, right? Maybe it was like a couple people, they might have something there, but
Yeah.
uh, yeah. Well, thanks, Amy. I really appreciate you sharing that.
You.
Yeah. Now I'm going to pass it over to Caitlin, who's going to take some questions for the Q&A.
Yeah, hi everyone. And thank you so much, Dylan and Amy, and of course to Will for being on this call. I'm Caitlin. I'm one of the national organizers with EWD. This first one comes from Melissa, and these questions will be for Will, not for me. How many times do we have to say, I invoke my wine garden rights? I've been told to say it loudly 3 times, like Beetlejuice.
Yeah, I mean, legally speaking, you should only have to do it once. Just saying, if this meeting could lead to any adverse action against me, I request my union rep be present. That's enough, technically. It does if you say that and they don't abide by it, if they don't provide you, say it again. Ask again. At a certain point, if you have requested your Weingarten rep and they have denied you, at that point, what you are doing is laying the groundwork for the grievance that's going to follow, or for the unfair labor practice that's going to follow. Unfortunately, the kind of general rule around these things is obey now, grieve later. It's not great, but if you very clearly establish that you have requested your Weingarten rep and they refuse to abide by it, probably the best action is going to be um, to go into that meeting and shut up, don't say anything, and file a grievance later. But if you are pulled into a meeting like that and you asked for your Weingarten rep, they didn't provide it, and that meeting leads to a discipline, you're going to have a pretty strong case to beat that discipline.
This next question is from Kathleen. It says, we work in grocery stores and customer comfort is part of the job. Many of us have new language that addresses staffing. So new contract language in the West that just settled in the last month. But the burden of proof for understaffing is on us. Can we take photos of long lines or other issues when customers might be in the photos?
Hmm. So that is going to be a complicated question to answer because that's less about labor law or contract, and it's more about privacy law, which is going to vary state by state. Different states have different rules on these things. My top line is going to be consult a lawyer in your state for the specific answer. Um, as a general matter, people don't have a reasonable expectation of privacy in a public place like a grocery store. Um, so that is the general principle. I won't say anything beyond that at this point because the state law just kind of really varies. But to the extent you are doing it, I would avoid faces or other identifying features of customers in documenting the issue. I mean, the other thing, and this is actually maybe more crucial, I'm guessing most of your grocery stores have a pretty extensive array of security cameras. And so, like, do whatever documenting you do, it's also, I think, a really valuable request for information to request security camera footage that might reflect line length over a relevant period of time. That's a great RFI, especially if there's a grievance over that, in some way involves what customer wait times were like.
Okay, so this next question comes from Aaron. Aaron works in a meatpacking plant. And Aaron says, the medical in my facility is a private contractor. So if I request medical information, medical says no due to their contract with the company. Is this legal under labor law?
I have a number. I'd have a number of questions about that, specifically what they mean by contract with the company. Um, as a general matter, if the employer has access, if it is within their control, then they have an obligation to provide it. Now, obviously, part of what they might be doing with the contracting relationship, one of the reasons they might be doing it is so they can say, well, we don't have control over that. The company we're outsourcing to has it. We can't do anything there. That gets into a really complicated question of like third party RFIs that like probably too messy to get into here. But they can't just, say, well, it's another, we have a contract that says we're not going to provide this. The contract they have that is important here is the contract they have with you and the legal obligations they have to you under the CBA and under their exclusive representative, being recognized by the NLRB as the exclusive representative of those workers. So um, it's a complicated question depending on the specifics of your situation, but simply because there's another company handling it is not a good reason to not provide you information that's within their control.
We've got another question from Katie. It says, if a steward or rep is not available or reliable for fair representation, does the member have a right to ask a coworker or a fellow member to accompany them in a meeting, at least to be a form of support or a witness?
Yes. So, and my brain's immediate reaction was there's a particular case I want to go reread really quick, but obviously we don't have time for that. As a general matter, the member, like the person facing the discipline, has the ability to decide who is going to represent them from the union. If there are multiple stewards on a shift or around, they can pick. The company can't force them to use a particular person. Um, so if a steward is unavailable, they can bring someone else in. I will say that and this is part of why it's important as a steward to educate everybody in the shop around all these roles. That person might not know their rights in representing someone as in a Weingarten meeting. And so making sure people broadly understand that can be useful in that situation. I mean, the other thing is if someone's asking you to come into a disciplinary meeting and you say, I want my steward, and there are no stewards available, you can push that meeting off for, not forever, but for like 24 hours to get someone. There's a case that involved someone getting called at like 1 in the morning by a boss who insisted on having an investigatory conversation right there on the phone. The member had a right to say, no, my steward isn't present. I have my Weingarten rights. And my steward isn't picking up at 1 in the morning, so we'll have this conversation tomorrow. So if they try and have a disciplinary or investigatory conversation with you and your steward isn't available, within reason, you have some ability to say, not right now, not until my steward is available and able to be with me in this meeting.
So just to clarify, you could ask, like, if you don't have a steward on your shift or that you but yeah, let's say the steward's not available, but there's someone else who acts like a steward, which we often see in UFCW shops, especially that there's someone who's really active that, is knows their rights and knows the contract really well, that you would want to represent you. You can request them to come into the meeting, but they wouldn't have equal legal rights as all of
I,
the legal rights that stewards have in the training we just went through.
again, there's a case I'm thinking of that I do not have on hand that I would want to review. Generally speaking, a member has the right the member can pick who from the union is representing them as their representative from the union. It's not that that person would have fewer rights, it's just that person might not know what a Weingarten rep can do in a meeting. Um, but yeah. Also, I mean, some of this also really depends on the contract. The contract can kind of shape the way the Weingarten right is invoked within reason. So yeah, that's my lawyerly way of saying I don't want to answer that without knowing more.
So this one from Melissa says, can you ask a customer to be a witness? Say the management is being disrespectful to an employee and a customer notices it.
That's a complicated question. I'm not sure what the answer to that is. I think what I would say is it's probably safer if that request is more formal and comes from the union through the steward than if like I wouldn't just like grab someone off the floor and be like, come into my disciplinary meeting and speak on my behalf. Because that, I think the employer has a reasonable right to expect that the collective bargaining process doesn't take place in front of the customer. Obviously, that can be harmful to the business operations of the business, which the law really respects. I do less so, but the law really respects it, and so that has to be kept in mind. Um, but yeah, so that's a really complicated question that I don't know if I could provide a good answer to on the spot, unfortunately.
Well, one thing that I would say from an organizing perspective, not a legal perspective, for Melissa, is that you might think about it as that's like a pretty intense escalation in organizing tactics that management, as Will pointed out, really hates. For people that work in customer-oriented or retail jobs, your relationship with customers and the company's kind of reputation among customers is one of their most valuable assets. And anytime that reputation or that relationship is challenged, it really scares the hell out of the employer, out of the company. So if your example is that there's a manager that has a chronic issue of being disrespectful and disparaging workers in front of customers or behind closed doors, and it's happened to enough people enough times that multiple regular customers have noticed it or have mentioned it. If you could get written statements from or get them to sign on to some sort of petition or pledge, or just piece of paper that says like we witnessed disrespect of our favorite cashier, and we want it to stop. That would be a really powerful organizing tool that you and your coworkers could use. This is not legal advice or has nothing. I don't know anything about where the law stands on this, but from an organizing perspective, I don't see why not. Okay, so some more questions. The one from William that says, when it comes to deadlines, are those case by case, or is there generally a specific, for instance, 60-day period where things must be grieved or resolved?
Yeah, so that those timelines are all going to be in your contract. The contract is what's going to dictate the timeline and deadlines for grievance filing. So I think the way this is usually structured is there'll be a section on step one and it'll say like this is how you file step one of a grievance, and step one of a grievance has to be filed within X number of days after the member or the union learned about the violation. And then it'll say like, and the employer has X number of days, 15 days, 10 days, 20 days to respond. And then you can escalate to step two and you have X number of days after the response. So all of that is going to be laid out in your contract. There aren't rules of general applicability about that.
All right, and then it looks like the last question we have in the queue comes from Austin. Says, has anyone asked about Weingarten rights in a non-union context? For example, if employees won an election, but they don't have a contract yet.
Yeah. So on the non-union context, that is a bit of an open legal question on whether folks have Weingarten rights even if they don't have a recognized union. Um, it's not that it's like it's basically the courts haven't said. When Jennifer Abruzzo, who was general counsel of the NLRB for 4 years from 2021 to 2025, came into office. She had a list of her priorities. One of those priorities was bringing that question to the board. Her position was yes, non-union employees do have Weingarten rights. Obviously, the board's character has changed. So I would say I wouldn't count on having your Weingarten rights in that situation. Now, in the scenario you laid out, where workers in a shop have won their election but they don't have a contract yet, those folks would have their Weingarten rights. Weingarten rights don't stem from a particular contract; they stem from an exclusive bargaining representative being recognized in the shop. So if you have a union that's been recognized by the NLRB, you've won an election or you've gotten voluntary recognition, workers in that shop have their Weingarten rights even if they don't have a contract yet.
Great. Well, that's all the questions that we had in the queue today. Um, so thanks again, everyone, for coming to this training, for being part of the movement to build a stronger and more member-driven union from the bottom up. Solidarity and good night. We'll see you soon.